Good afternoon, Your Honors. Beth Garrison of the Sumner County Bar. I represent the appellants, the estate, and the trust of Dorothy Huddleston, as well as the individual heirs. What we're asking the court for...
Do you want to reserve any time?
Oh, I'm sorry, Your Honor. Yes, I wish to reserve 3 minutes for rebuttal. Thank you. What we're asking the court for here today is to reverse the trial court's ruling. The trial court made a consequential error in allowing testimony of Mr. Chad Wilson, and the entire ruling of the case hinged on that error. We're asking the court to set aside that order, vitiate this real estate contract, and declare that it expired on May 3rd, 2021, when it was not closed. The parties in this are the appellants. They were represented by real estate agent Chad Wilson. The appellees were represented by Chuck Thomas, a real estate agent. He was also a member of the LLC that is a party in this case. I'm going to briefly go through the pertinent facts. There are a lot of facts in this case, but the matter involved a real estate contract for the sale of approximately 40 acres in Sumner County, Tennessee. The seller was Dorothy Huddleston, an 84-year-old widow. The buyer was Jetton Developments, an LLC engaged in the development of real property. The parties entered into a written contract which provided that the sale was to be closed no later than May 3rd, 2021. There were also several contingencies in that contract related to rezoning, annexation, that type of thing. The contract also provided in more than one location that any modifications to that contract had to be in writing and had to be signed by both parties. There were amendments to that contract which were signed by both parties regarding the sales price. It also had a specific provision that if the closing date were to be extended, that also had to be in writing and signed by both parties. So in addition to the general provisions, there was a specific one for the closing date, and it even went as far as to specify what form should be used to extend that closing date. The buyers realized they weren't going to be ready to close by May 3rd due to the contingencies. Their representative and their member, Chuck Thomas, prepared a written addendum to extend that closing date. He signed that on behalf of the buyers. The seller, Dorothy Huddleston, never signed that. There's no dispute as to that. There are various reasons given by her agent as to why it wasn't signed, but nobody disputes that it was not signed. The deal was to close no later than May 3rd, which was a Monday. On Friday, April 30th, Dorothy Huddleston unexpectedly passed away at her son's home in Indiana. Her son had to remove the hinges on the door to get to her body in the room. He notified her agent on May 10th, the first business day after her funeral, that she had passed away. At that time, he wanted to continue, and the heirs wanted to continue with the closing. After further discussion with his sisters, he notified the agent on May 17th that they did not wish to proceed with the sale. One of the sisters had decided she wished to retain the family farm and continue that legacy. At trial, Chad Wilson, the deceased's own agent, testified that he had had a phone call with her wherein she agreed to extend the closing date. He is the only one who heard her agree to this extension. It's nowhere in writing. No one else heard her agree to it. That is basically what the court based the ruling on. The trial court ruled in favor of the buyers, ruling that they operated under the understanding that that closing date had been extended based upon that sole phone call heard only by Chad Wilson. There are a lot of moving parts to this case. It's really almost a law school exam question just waiting to happen. There are a lot of elements here, but really the crux of it all comes down to that alleged phone call and that alleged agreement, which was only heard by Chad Wilson. Without Chad Wilson's testimony, what do we have? We have a written real estate contract that was not closed by the closing date and should have expired on that closing date. The issue with Chad Wilson's testimony can be distilled into three different categories: competency, admissibility, and credibility. The competency comes into play with the dead man statute. At trial, I objected to Chad Wilson testifying. The court ruled that he was an agent and therefore could testify as to what Ms. Huddleston told him. That written real estate contract also provides and has a specific provision that agents cannot bind the parties absent written agreement. That's in that original contract too. There's no written agreement that Mr. Wilson could bind Ms. Huddleston, and specifically not for this closing date, of which there was another specific provision that it had to be in writing. Second is admissibility.
Why does the dead man statute bar Mr. Wilson's testimony?
Why does it?
Yes.
Your Honor, he is not a party. The ruling of the trial court was that he was an agent, which effectively made him a party able to testify. He was called by the opposite party, so it did meet that requirement. But our contention is
I'm sorry, it met what requirement?
that in order for the testimony, in order for the witness to be competent to testify, they must be called by the opposite party.
And Mr. Wilson was not a party, is that right?
He was not.
The rule doesn't apply, does it?
I don't believe it does, Your Honor.
No, it doesn't apply.
And so the court ruled that he was an agent, but we have issues with that as well. So that was the first threshold issue. The second is strict hearsay. The declarant is unavailable, but her alleged conversation with Mr. Wilson does not fall under any of the 5 categories. It's not former testimony, not a dying declaration, not a declaration against interest, not a declaration of pedigree, not forfeiture by wrongdoing. So it's not admissible under hearsay. That objection was overruled as well. But the more interesting element
is it admission?
I'm sorry?
Is it admission?
I don't believe it is, Your Honor. No.
You don't believe it's an admission?
It's not an admission. Because
Is she a party opponent?
her estate and trust is now a party, yes, Your Honor. But it was not, at the time, it was not known that that was going to be the issue. It was all governed by that written contract. And there was nothing done in writing to memorialize that alleged agreement. So even if you get past those 2 threshold issues, the credibility of Mr. Wilson is very much in question. Now, I understand that that's a high threshold, that courts give a lot of deference to the trial court on evaluating a witness's credibility. But if Mr. Wilson's bias is not clear and convincing, I honestly don't know what is. His bias becomes apparent before the lawsuit was even filed. He testified that as soon as Roger Huddleston called him on the 17th to tell him that they no longer wanted to go through with the deal, that he told Roger Huddleston that there would be reciprocity, that the buyers would want reciprocity because of the money that they had spent. So he was already laying the groundwork that this needed to get to the closing table. He also told Roger Huddleston that the property was still under contract. This was on May 10th and May 17th, even though the contract had clearly expired on May 3rd. And he was still communicating with the buyers about the necessity of getting a written extension of this closing date. They were going down the avenue of a probate needed to be opened, someone needed to be appointed, but he had conversations with both Roger Huddleston and the buyers that a written extension needed to be executed. So he knew it was no longer under contract. Even if you disregard those issues, Mr. Wilson's testimony is riddled with inaccuracies. He testified that Roger Huddleston called him on the morning that his mother passed away and said that his mother had passed away that morning. She did not pass away until that afternoon, at 4:30 in the afternoon. So his credibility is and his recollection is in question there. But to believe that Mr. Huddleston called the real estate agent after he had literally had to take apart the door to remove his mother, to talk about a closing that he didn't even know had been set. Roger Huddleston testified they didn't know when the closing was. They didn't get a copy of the sales agreement. There were no plans made to schedule the closing for May 3rd. So to believe that he would immediately call Chad Wilson to discuss this closing is simply not believable. Mr. Wilson consulted with Jetton's counsel, Mr. Jack Friedel, before this lawsuit was filed about suing his clients, the appellants, to get his commission. Mr. Wilson cooperated with opposing counsel to provide the listing contract, which was not in the public record. And that contract—
Wasn't there a subsequent conversation with Mr. Roger, was it Roger Huddleston?
Yes, Your Honor.
After the closing date? Mr. Huddleston testified that a conversation occurred on May the 10th in which he communicated his intention and desire to follow through with the closing?
Yes, Your Honor.
And I know we keep referring to this property as being owned by Ms. Huddleston, but in fact it was in a trust, wasn't it?
It was, Your Honor, and that issue was addressed in a motion for summary judgment. It was owned by a trust, which was public record, but up until the lawsuit was filed and we responded, no one besides us realized that it was in a trust.
Well, I guess the point I want to ask you about, though, is when Mr. Roger Wilson indicated his intention and desire to follow through with the contract on May the 10th, he in fact was a successor trustee to this trust. So he had the authority to make that communication.
He did, Your Honor. At the time, he did not realize he was the successor trustee.
I understand he didn't recognize, he may not have realized it. The fact is, he was.
He was, Your Honor, yes,
All right.
yes. Chad Wilson even testified at trial. Oh, so Chad Wilson provided a copy of the listing contract to opposing counsel. That was attached to the complaint. He did not seek permission from his clients. He did not notify his clients that he was doing that. In addition, Mr. Wilson testified at trial that he wanted his commission. It was a nice commission, he said. He testified that he gave a copy of that listing agreement to opposing counsel because sharing that copy benefited him. I asked him, did he not have a fiduciary duty to his client? And he said he also had a fiduciary duty to himself, and he wanted his commission. He testified under oath to that effect. So all of this, Your Honors, goes into his credibility. He has so many questionable actions, statements under oath. He was in it for Chad Wilson, and he was the only one who heard her allegedly agree to this extension.
As I understood, the son was present at the time of that conversation with Mr. Wilson. Is that disputed?
It's disputed as to how long he was present, Your Honor. He was present when Mr. Wilson called, but also Roger Huddleston stated in his testimony that his mother was very private about her business affairs. She would take the call and go into another room. So he did not hear the actual conversation between her and Mr. Wilson. He only knew that Mr. Wilson called. And he also testified that she never told him whether or not she agreed to the extension.
Did the judge make a credibility finding as to Mr. Wilson?
He made no credibility findings, Your Honor. He adopted the findings of fact and conclusions of law of opposing counsel pretty much whole cloth, only added a couple of paragraphs about attorney's fees.
You have a contract where the sale is supposed to take place on May 3rd, and then the owner dies on April 30th. Does that in and of itself necessitate a continuance of the closing date?
I don't believe it does, Your Honor, because throughout the transcript, it was evident the buyers never intended to close on May 3rd. There was no closing scheduled. There was no title search done. There were no funds transferred to the closing company. Ms. Jessica Hunter, the owner of the closing company, testified. She last heard about this closing on January 28th, 2021, and she heard not another word about it until I served her with a subpoena ducis tecum in July, I believe, of that year. So even though her death, Ms. Huddleston's death, was in close proximity to the closing date, it was clear that the buyers never intended to close on May 3rd, and they had prepared that extension of the closing date. So their actions showed that it wasn't going to happen on May 3rd. They claimed that they were able to, yet their first appearance before the zoning committee was the evening of May 3rd, so those contingencies could not be met.
And was that zoning change approved on May 3rd?
It was the second reading, Your Honor, and I believe that was a preliminary finding, and it still had to go through another process. The annexation had to occur, and then there were also some issues of how many water taps and that type of thing could be attained. So the zoning was preliminary. It was not completed on May 3rd. So, Your Honor, I realize that it's a...
Any further questions? You'll have your rebuttal.
Oh, well, thank you, Your Honor.
Hear from the appellee.
Good afternoon. Police Court. I'm Jack Friedel from Sumner County. Judge Armstrong, you asked a question of opposing counsel that kind of touched on something I really wanted to say about this, and this is not the fact that the case turned on, but it could have, and I think it's important to note there's a human element to this. Mrs. Huddleston died. If there had never been any conversation at all about continuing the closing date, if that had not existed, there would have been a contract period that would have expired on May 3rd. Mrs. Huddleston died unexpectedly on April 30th. She wasn't buried until May 8th. At some point, you got to think, well, okay, so my seller's dead, I'm the buyer. Obviously, there's no one coming to closing on May 3rd. So it's not like the buyers are going to be pounding down their door going, hey, we have to close. So
did that sales agreement bind her heirs and assigns.
Yes, sir, it did. It's expressly binding on heirs, successors, and assigns. It's the standard HUD contract that all real estate professionals use, and I've cited that in my brief. It's part of the contract.
Well, property was in the trust anyway, wasn't it?
Yes, sir.
And we had a successor trustee.
Yes, sir. Anyway, the opposing counsel's argument, she's attacking Chad Wilson. She's asking the court to, I think her argument is that you should believe Mr. Huddleston and everything that Mr. Huddleston said, and the chancellor should not have believed Chad Wilson, but the court found Chad Wilson to be credible. It's implicitly.
Did you say implicitly?
He made no express finding that I find Mr. Huddleston to be not credible or Mr. Wilson to be credible, but he made his findings and rulings based on Mr. Wilson's testimony. And Mr. Wilson's testimony was actually that Mr. Huddleston called him the day that his mother died. Court found that to be credible. Counsel would have you find that that's not a reasonable thing to do, but life goes on, and if you've lost a parent, you know that sometimes you have to conduct business, and what more important thing business had to have been conducted than to let the buyers know that his mother had died. So I don't find that to be any reason to think that Chad Wilson was not credible. Most importantly, though, the conversation on or about April 8th, I think it was April 8th, Roger Huddleston was there. Chad Wilson said, I could hear him on the other end of the phone. He joined in the conversation at one point. He knew what the conversation was about, and he actually told his mother, go ahead and agree to it. That was the testimony that the chancellor heard at trial. So, dead man statute doesn't bar him from testifying, and quite honestly, hearsay doesn't bar that testimony either. That's him talking directly to Chad Wilson. So, long and the short of it is, Mr. Huddleston knew, or should have known, that he was a successor trustee. He was a successor trustee. He knew that there was a closing pending on the sale of his mother's home. If he claims he didn't know when it was supposed to be, either the original date or the extended date, then that's part of his duty as a successor trustee. He knew or should have known that. But our position has always been at trial, it was testified to, like I just said, that he expressed to the sellers through their agent, Mr. Wilson, on the day that his mother died, that they were going to follow through with the contract. By his own testimony, a week later, on May 10th, a week after May 3rd, if you strictly only believe Roger Huddleston's testimony, he called the agent, Mr. Wilson, and expressed, we're going to follow through with the contract. So he led the buyers to believe that the contract was extended, and they relied to their detriment on those assurances. And
what did they do to their detriment? What expenditure?
They continued to work on that, and as the court found, they continued to, well, first of all, they could have closed by May 3rd. They absolutely could. If Roger Huddleston had said, Mama's dead, we're going to close tomorrow, they could have done that. The testimony was they had cash in the bank. They had working capital. My client testified to it, and they also had a line of credit they could call on if needed. So they could have gone to the closing table right then. So they relied to the detriment by not doing that, and they continued to work on it. And as you pointed out earlier, on the night of May 3rd, he appeared at the Portland Planning Commission, or the Portland City Council, rather, and the rezoning was approved on second reading and passed. So they were continue to work on this, continue to expend their time and their effort on it, and again, relying to their detriment by not insisting, well, if you want to insist on a closing before May 3rd, then let's do it. But Roger Huddleston didn't do that. Roger Huddleston, by his own admission, an additional week later, if you believe Roger Huddleston, said he simply changed his mind on May 17th because he just didn't want to do it anymore. And that's when they called and said, we're not doing it. I actually believe that it was later than that in June, but we'll take Roger Huddleston's testimony. May 17th, he just reneged on what he had already said as successor trustee he was going to do. So they acquiesced in the extension of the contract, and the court found that the doctrine of equitable estoppel applied to bar them from denying that they acquiesced in that. And that's what the case turned on. But like I said, if none of that had ever happened, the seller dying would have, based on in my opinion, the implied covenant of good faith and fair dealing, you would have had to have waited till somebody could come and represent the seller at the closing. And it certainly is not going to be before her funeral. It would be unreasonable. So at some point, it was presumed that we'll get a closing together once they have buried their mother and had a proper grieving process. And May 17th, Roger Huddleston said he wasn't going to do it. So that's what happened. So like I said, the Chancellor gave weight and credit to Chad Wilson's testimony, and Chad Wilson was a credible witness. Roger Huddleston, on the other hand, said some things that were pretty incredulous. I mean, he admitted on the witness stand that he hadn't even read the trust. Now, on the day of trial, on the witness stand, he admitted that he hadn't read the trust, and he didn't know what his responsibilities were. So I don't really have anything else to add, so I will cede my time unless the court has any questions.
Any questions? Thank you.
Thank you.
Garrison, you have 3 minutes.
Mr. Friedel tries to invoke the human element that the buyers wanted to give sufficient time for mourning before they tried to close. If you look at the testimony of Roger Huddleston, he called Chad Wilson on the 10th, the first business day after his mother's funeral. Chad Wilson wasn't even aware that she had passed away. So the buyers were operating and let the closing date pass without any attempts to close. The testimony of Jessica Hunter, who was the owner of the title company, arguably the only completely unbiased witness in this entire matter, she testified that there are documents exchanged in advance of closings. As of the Friday before this was supposed to happen on Monday, none of those documents had been exchanged. No ALTA statements, no title search had been conducted. These buyers were not going to close on Monday. They try to frame it as they were, and they would have if Ms. Huddleston hadn't passed away, but that's simply not true. They had not taken any of those actions. Those contingencies were not met. And they knew that they needed that written extension. They continued to discuss with Mr. Wilson, even after her death, we need to get somebody to sign a written extension. They knew it had expired. What happened was the real estate agents in this case got comfortable, they got complacent, and they got sloppy. And then they got in trouble when Ms. Huddleston passed away. They were going to attempt to run this through on a handshake informal deal, and they didn't even exercise the most basic tenets of real estate law, which is to get things in writing, especially when the contract specifically calls for it. So they mean to present themselves as being ready to close on May 3rd. They took absolutely no actions which would lead you to believe they were ready to close on May 3rd. And even if there was this alleged extension, there were 4 dates discussed for that extension. There was June 3rd, a month after the original date. There was July 16th, which was what was included in the amendment to extend the closing date, which was never signed. There was once the contingencies are met, that was the 3rd date, and then there was as soon as possible. So there were 4 separate dates that were discussed to extend this. Before even the first alleged extension, June 3rd, had come, they were already talking about a written extension and the need for that. If they all believed that it had been extended and they were operating on this extension, then why would they still be concerned about a written extension? Because they knew that it wasn't extended. They knew the contract expired on May 3rd when they didn't close it. And they're trying to shoehorn these facts into the laws to try to make this deal go through. And Chad Wilson is especially interested because of his commission. So we ask your honors to set aside the trial court's order, vitiate this contract, and hold these alleged real estate professionals accountable.
Yeah, let me ask you, the extension request by the buyers that was delivered to Mr. Wilson, what was the date of that extension?
That was prepared, I am wanting to say, if I can grab my notes, I believe it was April 8th.
So on April 8th or sometime before that, they requested the extension, and they thought, believed from Mr. Wilson's statements that she had agreed. That extension was sent to Mr. Wilson, who was supposed to then get it to the owner to sign.
Yes, Your Honor.
And that didn't happen for whatever reasons.
And Mr. Wilson testified that he didn't receive it immediately after it was prepared. I believe he claimed it was in his spam folder, and then he had various reasons why it wasn't signed. But the buyers recognized as early as April 8th, I believe it was the 8th, but it was in April, that they were not going to be able to close on May 3rd.
And then after Mr. Wilson didn't get the extension back, they contacted him again. And then he realized it was in his spam folder, and then that's when he was supposed to get with the owner to get it signed.
Yes, Your Honor. And he testified that he always went to her house to get documents signed. And he testified that he was going to get that signed on or around April 30th. He was going to go to her house, but he wasn't even aware that she was in Indiana. So he made no real attempts to schedule anything to get her to sign that before the May 3rd closing date.
Thank you.
Thank you.
Well, one last question. So at the end of the month, 3 days before the closing, she's in another state with the intentions of returning when?
I don't know when the intentions were because she and her son did not know about the closing date. They'd not been informed. So she would,
She obviously knew the closing date of May 3rd. That was on the first document that she signed.
Mr. Huddleston testified that he was not aware of that closing date and that if she had been aware, he would have been aware because he did all of the transportation for her because of her health problems. So though she signed the document, I can't say that she was aware of it, and their actions did not indicate that they were preparing to come back for a May 3rd closing date. And she did not use computers or anything like that.
Well, they would not prepare to come back for a May 3rd closing date because she thought she had agreed to an extension, maybe not in writing, but she had orally agreed to an extension.
I respectfully dispute that, Your Honor. I believe that that Mr. Wilson's testimony is retroactive to try to make these facts work. From the testimony, it appears to me that Ms. Huddleston was relying on her agent and that she had not been informed of a May 3rd closing date because that was not going to happen on May 3rd.
Thank you.
Thank you, Your Honors.
Thank you, counsel. We will take the matter under advisement and issue an opinion as soon as possible. May leave.